Okay, good morning, everyone, and welcome, or indeed for many of you, welcome back. It is now 9 o'clock, and so I resume the hearing as part of this examination of the York Local Plan. First of all, can everyone hear me well enough? Okay, very good, thank you. Can I remind you, please, that if you do have a mobile phone or other electronic gadget with you, if you've brought a Game Boy or something like that, then please make sure that it's switched off while the hearing's in session. And if you haven't already done so, please make sure that you sign today's attendance list before you leave. If we do have any members of the press present, please can I ask that you sign the same sheet, but do make it clear which media outlets you represent. If I could ask someone from the council to remind us what we should do in the event of a fire or other emergency.
So I'll do it today. There's no scheduled alarm practice today. If the alarm goes off, please exit the hearing room by the main exit and go down the stairs out the main door of the Gimcrack building. Make your way through the entrance building to the point under the footbridge on the road outside the venue.
Thank you for that. And should there be a need to follow that evacuation procedure, I would urge caution in walking outside of the building so that you avoid tumbling on the black ice, which a fate I didn't manage to avoid earlier this morning. The council, as previously, is video recording our proceedings today, and I understand that the council's keeping a list of people who have agreed to that. Can I just check that everyone participating has either signed that list already or is otherwise happy to confirm? Well, frankly, is everyone around the table happy with being recorded? I shall take the silence to be agreement. Okay, I'm Simon Barclay, and this is my colleague Andrew McCormack. We are both planning inspectors and chartered town planners. We've been appointed by the Secretary of State to hold this examination into the soundness of the local plan and to produce a report of our conclusions and recommendations on any actions or changes needed in relation to soundness. Specifically, then, our role is to assess whether the plan satisfies the requirements of the 2004 Act, the relevant regulations relating to the preparation of the document, and whether it is sound. In order to be sound, the plan should be positively prepared, justified, effective and consistent with national policy as defined, by and large at least, in the National Planning Policy Framework, the NPPF. Carol Crooks is our programme officer and is currently on door duty, as she is most mornings. She's an independent officer of the examination, working under our guidance, undertaking the administration of the examination, and in effect acting as a conduit for communication between us and everyone participating. She generally works very hard to make sure that the examination runs as smoothly as it possibly can. So if you do have anything that you need to raise with us at any point outside of the hearing sessions, then please go to Mrs. Crooks. Yeah, just a couple of reminders. I mentioned just now the NPPF. Just to be absolutely clear, this examination is proceeding under the transitional arrangements, which means in effect and in short, that it is the NPPF of 2012 that applies. And when anyone around the table refers to NPPF or national policy, we will assume that you are talking about the 2012 NPPF. So if you do mean something else, then please make that absolutely clear. Also, for the avoidance of doubt, what we are examining here is the local plan as it was originally submitted. You will be aware that the council has put forward some suggested modifications to the plan. Those aren't currently, at least, modifications that we have endorsed. So, as previously, any modifications that the council has suggested, we will discuss as we go along. If there are any further changes proposed by the authority or indeed others, they should only be advanced if necessary to make the plan sound. The council is free to make any minor modifications as it wishes, and so we don't need to consider those. And our report, well, our examination is focused entirely on the question of soundness, and our report will only specify any changes needed to make the local plan sound. Yeah, for the benefit of those that haven't attended previously, I will just mention that this is phase one of the hearings, as you will be aware, and following these phase one hearings, if we consider that the plan is legally compliant and there's a reasonable chance that it can be found sound in relation to the phase one matters, then the hearings will then move on to phase two. I'm not going to say any more, I don't think, about that. As previously, yes, tempting though it may be for some, we are not focusing on sites at present, whether they are proposed in the plan or not. So whilst I know that some of you have a fondness for certain areas of land, I ask that you focus your comments on the things that we are talking about today and try not to drag us down that particular path. So our guidance note outlines the procedures to be followed at the hearing sessions, the way in which written representations will be dealt with, and the availability of information. As previously, today's hearing session will be in the form of a loosely structured discussion, which we shall lead, and I'll generally be following the Matters and Issues paper that's been circulated. I haven't produced any separate agendas or anything like that. I like to try and keep things as simple as they can possibly be. As the hearing sessions go along, we will invite people to speak at particular times, but if you are sitting there desperately trying to get into the discussion and finding it difficult to do so, please append your nameplate and we'll bring you into the debate at an appropriate point. Yeah, I should say we have set what is potentially quite a tight schedule. We are doing very well so far insofar as we've managed to keep to that schedule, and if we can all focus minds to attempt to keep up that good record, then I would be very grateful. And as an incentive, just to remind you that we have set Thursday this week as a reserve day, and so I do ask people to be prepared to attend on that day if it is necessary, i.e. If the discussion today should overrun. I'm rather hopeful that we won't be in that territory. Today we will take, as previously, a short break around mid-morning time and another short break at some point this afternoon, and one never knows one's luck, potentially a slightly more luxurious break for lunch. I think that's about all we need to say, so if we could have brief introductions around the table, and as previously starting on the council side.
Thank you, sir. Scott Linus of Council, appearing for the council.
Kennedy Sheldon, Development Officer for the City of York Council and the Forward Planning Team.
Richard Wood, Consultant, appearing for the council.
George Wright, Chartered Town Planner.
Alistair Willis, Planning Director at Lichfields for Bellway Homes and NHS Property Services.
Chris Wedgwood, Member of the Public.
Craig Barnes, Gladman.
Andrew Johnston from Avison Young, appearing for Oakgate Group. Thomas Pilcher from Pilcher Homes.
Keith Marquis, Stransellwith Towthorpe Parish Council.
James Seabury, Banks Group.
Andrew Bell, resident of York.
Morning, Mary Cook, Town Legal, Langwith Development Partnership.
Ian Smith, representing Historic England.
James Rawlings, Countryside Properties.
Richard Clark, York Constituency Labour Party.
Mark Johnson, Johnson Mowat, representing Red Roy Homes and Taylor Wimpey Homes.
Mark Lane, DPP, representing Linden Homes and the Shepherd Group.
Morning, Paul Butler, representing TW Fields.
Jennifer Hubbard, Planning Consultant.
Morning, Stuart Natkus on behalf of Bow and David Wilson Homes.
Morning, Matthew Good, Pegasus Group on behalf of Lovell Developments.
Stephen Pittam, I'm representing the York Travellers Trust.
Catherine Dukes, Directions Planning, representing Joseph Rowntree Housing Trust, Northminster Limited, Baskin Brown College, William Birch and Sons, and a private landowning family.
Tim Bewley, QC, Landmark Chambers, representing the Defence Infrastructure Organisation.
Steve Secker, representing the York and North Yorkshire Chamber of Commerce.
Eamon Keogh O'Neill Associates, representing Galtrays Garden Village Development Company.
Paul Tucker, Queen's Counsel, representing the University of York, and sir, I'm sharing a chair, albeit not physically at the moment, with Janet O'Neill of O'Neill Associates, who instructs me.
So, Ian Ponter of Council, instructed by Savills, representing the Retreat.
Joanne Oldfield, Carter Jonas, on behalf of Show and Clinic York.
Simon Grundy, Carter Jonas, on behalf of L&Q Estates.
Emma Winter, Carter Jonas, on behalf of Carbon Homes.
Michael Corsier for Heslington and Fulford Parish Councils.
Sarah Worthington for Erdon Planning on behalf of Mr Harrison, a local resident.
Thank you for that. Good morning all, and welcome to another high-octane day at the races. I probably ought to say, as before, in the interests of openness and transparency, there are, as previously, a few faces that are familiar to us around the table. Those are, by and large, people that we have met at proceedings previously, just like these, or one or two people that we might know from a former life. There are, though, neither friend, family, nor foe participating today, and as such, our... What's the word I'm looking for? Sorry, senior moment. Impartiality. Impartiality is the word I'm looking for. And so the point of all that being that our impartiality isn't affected one way or indeed the other. Are there any procedural points or questions before we move to the agenda for today? Very good, thank you. In which case then let us turn to matter 3, the green belt. And first of all, the question of principles, and this is question 3.1. Yeah, so the first question then, simply, or not, is paragraph 10.1 of the plan states that the plan creates a greenbelt boundary for York that will provide a lasting framework to shape the future development of the city. For the purposes then of paragraph 82 of the MPPF, is the local plan proposing to establish any new greenbelt? And yeah, the reason we asked this is, if we look at paragraph 82 of the MPPF, it says this: the general extent of green belts across the country is already established. New green belts should only be established in exceptional circumstances. And then it goes on to say various other things. So by and large, what we are seeking to establish here is whether in national policy there are two things, one called the green belt and the other called the general extent of green belts, or whether in fact those are one and the same thing. Do I look to you for this first off, Mr. Linus?
Yes, Sir, Mr. Wood will add to this. The way the council had approached this was that they'd started with the proposition that under paragraph 82, the general extent of green belts is already established, and that had applied in the circumstance of this case to the general extent that had been set down in the RSS. And because the RSS directed the council to set the inner and outer boundaries to that green belt, which had been established, that boundary setting exercise was to be distinguished from the creation of new green belt under paragraph 82, which the plan was not intending to carry out. So we did see a distinction between the general extent of green belt, which applied in this case, and the establishment of new green belts, which was not what this plan was seeking to achieve.
So just to be sure that I'm clear on this, I think the Council's position, in effect, is that the general extent of green belt is more or less the same as a green belt. It is a green belt. York does have, in fact, a green belt.
That's right, sir, and without going into a number of appeal decisions which have considered this, that is the position, yes.
And so you say then, as I understand it, that therefore you don't need to demonstrate exceptional circumstances for establishing a new green belt.
That's correct, sir. Under 3.1b, you do raise the question of sites which are proposed in particular within the general extent of the green belt. We'll come on to that later, but as a general proposition, that's right. We're not looking to demonstrate exceptional circumstances for the creation of new green belt.
So in the Council's view then, as a general principle, in allocating sites for development, which are presently in the general extent of the green belt, do you say that that is a alteration to the green belt boundary for which exceptional circumstances must be demonstrated?
So yes, the framework doesn't provide explicitly for the circumstances that are contemplated by putting new development in the general extent. But under paragraph 83, where it says once established green belt boundaries should only be altered in exceptional circumstances, we've taken that to mean that although putting new strategic sites in the green belt is not technically an alteration of a boundary, but is rather putting development within the the general extent of the green belt, it should essentially be treated in the same way, so that you are altering the green belt in a way that requires exceptional circumstances, and that's consistent with the underlying objectives of the policy. It doesn't fit entirely into altering a boundary when one's looking at putting a new strategic site within the general extent of the green belt, but a very similar approach should be applied, and we say that should require exceptional circumstances to be demonstrated. Essentially, you're putting development into an area where a green belt has been established.
Yes, it's quite a curious national policy position, isn't it, and local situation here in York. I think what you're saying, in effect, is that if I were to have in my mind that through this plan, step one is establish green belt, and then step two is propose to remove land from the green belt, then I'll probably be, so far as you are concerned, on the right track.
Yes.
And that's a safer way of going about things, is it?
Yes, you'll know from the correspondence that took place before the examination, that's the way it was expressed by the Council, because we recognise that the NPPF doesn't make specific provision for the approach that's been taken in the general extent of the green belt. But we thought that looking at paragraph 83, that where you have an alteration to the green belt in general terms through the release of land, including within the general extent, the underlying purpose of the green belt policy should require exceptional circumstances to be demonstrated.
And that is as set out in a legal opinion provided to the council, isn't it?
Well, the main legal opinion that has been provided in the examination library relates more to the approach to safeguarding, but in short, the approach that's being followed isn't inconsistent with what was put into that opinion.
Mr. Wright.
Good morning, sir. I've regrettably quite a few things to say on this point. And in order to try and deal with things efficiently, because there isn't any specific question that addresses the issue of reasonable alternatives, I'm going to pick that point up in this context of New Greenbelt, because I think it's easy to say there, and it'll save me separately dealing with it later on. So my position is that there are two possibilities here. One, that the entire Greenbelt proposal is for a new Greenbelt, and I will explain how I come to that conclusion in a second. But in the alternative, there is either land, significant and material amounts of land beyond the outer boundary provided by the RSS policy, and land within the inner boundary proposed by the RSS key diagram, and that must therefore be new Greenbelt. So if I can then just come back then to the concept that the whole process is, in fact, a proposal for a new Greenbelt. I make that proposition on the basis that what has been submitted in this plan is not an attempt to conform with the RSS policy. The history of this proposal is that it reflects the Greenbelt that was demonstrated in the York Greenbelt local plan of 1991. The only alteration to that proposal is that pieces of land have been removed.
Forgive me, Mr. Wright. I think I know where you're going. Does this relate more to question 3.2?
Well, sir, I think it relates to whether this is a new Greenbelt or not, and this is the point. I was going to say it under here rather than there. So the 1991 York Greenbelt is the basis of the Greenbelt that is in this plan. It has not materially changed apart from where development has in the ensuing years taken place, and a bit of land beyond the River Derwent.
For the avoidance of my doubt, Mr. Wright, when you say the 1991 Greenbelt, what Greenbelt is that?
The York Greenbelt local plan, sir, I'm talking about. And I have supplied you with, in my Annex 5 of my response, the plans for that. And you can consider those plans against this plan. But what happened next was the 1998 local plan, and that chose specifically to adopt the 1991 approach because that was a local plan inquiry, and the local authority wanted to avoid the objections being raised a second time. And so it decided to use the same plan and in an attempt to avoid it. That plan didn't get past the post because the proposal was for a short-term Greenbelt, which was the inspectors concluded was entirely unacceptable. But if we go back to the history of the 1991 plan, and I've again supplied you in my Annex 5 plans, the underlying plan that North Yorkshire used to create that green belt, and it didn't relate it to the 6 mile radius. What it did was it assembled a plan based on a series of sketch plans that had been produced by a series of minor local authorities, such as the Flaxton Rural District Council and so forth. And it used that, and then it added and subtracted pieces of land from that. So the thing about where you come to a conclusion with that process that went through to 1998 is that it was not evidence-based. It was not based on the structure plan policy. It did not conform with the structure plan policy. Because it was a local planning inquiry and the nature of the planning regime at the time, the inspector didn't have to consider the issue of conformity because he didn't have an objection on that point. So, unfortunately, it wasn't addressed. But what can be seen from the structure plan key diagram of 1980 is that it was a circle at 6 miles, and that was significantly apart from the county boundary, which is the eastern boundary of the district as it now stands. So it didn't go up to the boundary. Now, in 1995, when North Yorkshire produced a new structure plan, there was absolutely no change in the policy, and there was absolutely no discussion regarding the policy. Yet the key diagram showed the general extent differently. And nobody I know I can think of spotted it. And it was obviously just sneaked in under the fence because North Yorkshire, having secured their Greenbelt local plan in 1991, obviously wanted to reflect it on the key diagram. Unfortunate. But what that establishes is that clearly it didn't go up to the boundary, and the current Greenbelt proposal goes up to 7.3 miles from the centre of York, which is a...
When you say the current Greenbelt, you mean the Greenbelt proposed in this local plan?
In this plan. It goes even further than the 1991 plan.
My apologies, did you say 7 miles?
7.3. And it is clear that the general extent on a 6 mile radius, which again I've marked for you on a plan, shows a significant amount of land beyond that range, and that must be New Greenbelt. Also, the key diagram of the RSS indicates a inner ring, which is based on the outer prongs, if I can use that word, of the central built core. It is displayed in detail on the key diagram. It's not done like it was on the structure plan key diagram.
Just to be sure that I'm still with you, Mr. Wright. Are we talking now about the currently proposed Greenbelt? I missed what you said.
The current one. So the current one, based on the RSS key diagram, would have a boundary somewhere in the region of the outer ring road. But it doesn't. It goes right in to the centre of the city. So there's clearly a material amount of land in there that is New Greenbelt. And then finally on that point, that PPG2 1998 set out that the area of the general extent, and that was based on the 1980 structure plan policy, which required it to be at 6 miles, said it was 50,000 acres. The current proposal is some 38% larger than that area. So it seems to me that you've got to say that there is a new greenbelt here. And what I say is that you then need to look at the spatial strategy that the council has put forward. And what you find there is that it talks about an existing greenbelt. And I think it does that because it assumes, for a start, that the York Greenbelt Local Plan proposal is where you start from. And what you should start from is from the RSS policy. And the RSS policy indicates that the purpose of the Greenbelt is not only that it safeguards the special character and setting of the historic city, but also at Y1.2, protect and enhance the nationally significant historical and environmental character of York. So there is nothing in the plan. When we come to deal with evidence, I'll say that there is no evidence anyway. But they've tried to retrofit the evidence with the TP1 document and its addendum. But that has in it no identification of this policy about protecting and enhancing the nationally significant historical character of York. It does refer to some national environmental site, but not anything to do with the nationally significant historical character. It's not been identified. So this is not a greenbelt that is aimed at the policy. It's a greenbelt that it was just convenient to use because somebody else had done the work, but that work was done without an evidence base and on a different policy. So I would have expected that the evidence base would have displayed some explanation of what was the development limits that would be needed to safeguard the special character and setting. But the way that the council have approached it, this plan, is that they have assumed this greenbelt, and their whole spatial strategy is then based on how they fit in the development requirements. At paragraph 4.13 of the addendum, they say, previous strategic plans have established the general extent of the greenbelt for the purpose of preserving the setting and special character of the city as at approximately 6 miles from the city centre and incorporating the city's historic core. Well, it simply doesn't. The RSS policy does not incorporate the city's historic core. So they start from the wrong basis. It doesn't highlight the purpose, as I've said, which relates, if I might say, to the addendum paragraph 5.1. And then at 5.14 of the addendum, they say, given the size of York is approximately 6 miles across. Well, it isn't approximately 6 miles across. It's significantly more than 6 miles across. It's over 12 miles across. So they seem to use that as a basis of, oh, well, that means we can use the boundaries of the district. Well, that isn't what the policy says. And then sorry, I made the point about the inner boundary, sir, and the fact that that is not in line with the policy. And then when you get to the spatial distribution at 7.57, the options that they regarded were one, prioritise development, 2, prioritise development, 3, prioritise development, 4, prioritise development. These are not options to consider an alternative strategy for defining the boundaries of the Greenbelt. But there is a clear case that there are reasonable alternative approaches available to them. They could have started with a radius at 6 miles and worked from that and given reasons why they were departing from it materially, other than to go to the nearest definable physical element within the district.
They could have done. Do you say that they should have done?
Well, what I say is what they should have done is looked at some reasonable alternatives. And there are reasonable alternatives, and they haven't looked at any. All their reasonable alternatives are about reasonable alternatives for prioritising development. They have put, if I might say, the cart of development before the horse of defining the boundaries of the Greenbelt. They never attempted to sit down with a clean sheet of paper after 2013, when the policy had been established, and say, right, given this new policy and given the fact that the Secretary of State has now removed from the previous policy the point about coalescence with the neighbouring villages, we need to start and define our boundaries based on that. They haven't done that, sir. Now, if I might just quote from Harwood on planning policy, on the point of whether a plan is justified, he is, in this book, discussing it under the 2012.
My apologies. Who's Harwood?
Richard Harwood QC.
We often ask the same question. It's Richard Harwood QC.
Richard Harwood QC. Sir. I did say to you on Monday that I had discussed my case with leading counsel.
Yes.
It was Richard Harwood.
One thing I would say, Mr. Wright, is it's pretty clear to me that you are wandering beyond the current question from 3.1 and into 3.2.
So
given the historical period that you've covered, I think you've done that reasonably sort of succinctly, but if you could sort of go that final furlong quite rapidly.
So I just want to deal with this reasonable alternatives point, because just clear it off, because I indicated to you before these hearings that it applies not only to the legal compliance, it also requires to the soundness compliance. So Richard Harwood points out that obviously the 2012 MPF required it to be the most appropriate alternative, and that is no longer the case. And he quotes from the local plan expert group who suggests that a more liberal approach should be taken. And Richard Harwood himself sat on the local plan expert group. But he then in his book goes on to say, the authority does, though, need to explain how it arrived at the plan, considering other plausible options. And this, I say, there are plausible options for defining the boundaries. And he also says, whilst not simply substituting his own opinion, the inspector should look carefully at the alternatives considered, well, unfortunately, there are none for you to look at, and the justification for their rejection, and there are none of those either. So I say that the plan isn't justified for that reason, and I say that because the proposal is entirely out with the underlying policy of the RSS, What you are faced with is a proposal for an entirely new greenbelt, one which York think needs to take account of coalescence with neighbouring settlements and so forth, one which wants it to go in and go out. So I say to you that the plan is unsound for that purpose.
Yeah, on this occasion, I'm going to come directly back to you, Mr. Linus.
Yes, sir. Thank you. I'll ask Mr. Wood to supplement any points that I have. I mean, whilst the diligence in researching the history of the Green Belt is obviously to be applauded, we don't think that it really helps the examination to do that in this case, for the simple reason that it ignores the fundamental point that whatever happened before the RSS, you have a development plan that's been saved through its policies in the RSS, and that development plan policy is to be interpreted according to its terms. So it's unhelpful then to look back on the history which preceded that. Second point is that when you look at the RSS, it's important to acknowledge the flexibility that's built within it. The reference to the setting of the outer boundaries refers to about 6 miles from the city centre and the inner boundary. That is one element of flexibility. Secondly, the key diagram is not on any sensible view to be read as a proposals map. It is schematic for the reasons that have been addressed in earlier parts of the hearing. It gives a broad indication of the areas to be considered. Next, when one reads the key diagram with the policy relating to the inner boundaries in particular, which require you to safeguard the special character and setting of the historic city, it's not credible, we say, to look at those together and argue that all land within a broad dotted line should be essentially treated as excluded from the green belt towards the centre of York. The whole purpose of the policy was to give a broad indication of the area to be considered with a view to safeguarding the character of the historic city. And it's not right, we say, to argue that land inside that dotted line was not part of the general extent of the green belt. So for those reasons, sir, there is a degree of flexibility built into the policy. The key diagram should not be interpreted as strictly as is being suggested, and the reference to about 6 miles, we say, is entirely consistent with the approach that's been taken by the Council. And for those reasons, it's not right to say that new green belt, as contemplated in paragraph 82 of the framework, is being created. There are a few other methodological points raised by Mr. Wright that I think more naturally sit within later sessions of the...
Yeah, I think perhaps you should, Mr. Linus, have given a spoiler alert, because I think you've just given the answer to some questions that I have for you under question 3.2. So
right.
What I'll do is I'll hold you there for now,
well,
because Mr. Wright has covered question 3.1 and some things that I would raise under 3.2 as well. So if I hold your reply, the remainder of your reply for now, but in essence I understand insofar as relevant to 3.1, I think that, without wishing to put words into your mouth, what you say, and correct me if I'm wrong, but my understanding is that the Council says, no, we aren't creating any new green belt here, in effect, because our approach is in general conformity with the RSS, in short. Is that about the top and bottom of it?
Yes, I was going to deal with the general conformity point later on, but in short, yes, sir. It's another area where there's a degree of flexibility allowed.
Mr. Willis.
Thank you, sir. Yeah, it was just a matter of interpretation and how we review the MPPF policy, really. I think it's quite clear, in my view at least, that the general extent of the Greenbelt is established. There's a long history to it. It's set out within the Council's documents, but I think more importantly, as the Council's just explained to us there, it is adopted safe policy within the RSS. I think the difficulty we have is with the MPPF itself, which just does not deal with this issue of general extent being established but boundaries not defined. It's a very similar issue that we're dealing with in Northumberland. A few other people around the table are dealing with at the moment as well, with their local plan examination. And to that extent, I think it's almost helpful actually to turn back to PPG2, which does have some narrative about similar situations.
Can I just check that PPG2 is within the realms of everyone's recollection?
It's barely under mine, I'll be honest, sir, but I think it's helpful for context, if nothing else. So, for the record, paragraph 2.8 of PPG2 explains where detailed Greenbelt boundaries have not yet been defined, which is us, it is necessary to establish boundaries that will endure. They should be carefully drawn so as not to include land which is unnecessary to keep permanently open. Otherwise, there is a risk that encroachment on the Greenbelt may have to be allowed in order to accommodate future development. If boundaries are drawn excessively tightly around existing built-up areas, it may not be possible to maintain a degree of permanence that Greenbelt should have. This would devalue the concept of the Greenbelt and reduce the value of local plans in making proper provision for necessary development in the future. I think that point does start to lead into future questions on the agenda. I think the overall point being is that let's just be careful how we interpret the MPPF. It doesn't deal with this issue specifically. We're perhaps better dealing with the question under a kind of broad approach of paragraphs 83 to 86 of the framework in terms of how we define boundaries, but I don't believe we are establishing new green belts as a general extent in this local plan. Thank you.
Seeing as you mentioned it, Mr. Willis, I probably ought to ask, do you say that, well, what do you say about the weight that we should give to the thing formerly known as PPG2?
I don't think we can give it weight specifically. It's not a document that's in front of, well, it's not a published document as such. It's been rescinded. It's useful for context, really. It sets the background as to why we use this term general extent, which is obviously does feed through into the MPPF, but the MPPF just doesn't deal with the issue. I think the government famously got rid of 1,000 pages, which I thought was very helpful, and haven't picked up some of the nuances which were historically in policy.
Thank you. Mr. Natkus.
Thank you, sir. We've heard a lot this morning, but I think we've heard a lot of old documents that aren't necessarily in front of us, and ultimately I think it's relatively straightforward that we need to look at the RSS, so we need to look at the framework and the plan, because they're the three documents that are in front of us and form part of the library. The plan is grappling with the question of Greenbelt, and that's what we're here today to look at, as to whether it's new, whether it's defining, etc. And the RSS does give us some clues. The key diagram shows the general extent, but it also shows an inner boundary, which isn't coloured in as the general extent. Now, it could easily have been coloured in. Unfortunately, I wasn't around when it was drawn up as to why that may be the case, but there is a clear delineation on the key diagram that you can see.
Sorry, if you just bear with me, Mr. Natkus, I'm just going to grab that key diagram to hand. I know it's in several places, but can't immediately think of any of them.
TP1 might be the easiest
TP1
place.
addendum, sir,
Yeah.
which I suspect we'll have out at some stage today. EXCYC 18 is one place, and it's on page 8 of that document.
Page 8 was
yes.
that?
It's the smaller version. Hold on. Let's see if
Yes, that's a smaller version.
Yeah, the TP1, sir, which is the original topic paper 1. There's a larger version of it in figure 2 on page 7.
I have that. Thank you.
Thank you.
Yes, right. So I'm looking, Mr. Nackers, at figure 2, which is the saved RSS key diagram in document TP1.
Yes,
if someone has a larger copy, I would be great. I'm struggling to see a little bit.
Well, he's got it in TP1.
It's. Oh, well, it's, thank you, Mr. Wright. But no, that's a rare treat indeed. An original copy of the RSS in all its glory.
I think he's got it.
Right. Okay. Which I can see. So thank you very much for that, Mr. Nackers. So sorry, you were saying.
So I've got it on screen. So I think hopefully from that you can see that the general extent is coloured. Well, I'm not quite sure what colour it is. It's sort of a yellowy greeny colour blob, which is the general extent, and then there is a dashed green circle, which I'm guessing probably approximately follows the ring road. And anything within that area doesn't have the coloured hatching for the general extent of the green belt. Anything within that area is effectively white land. And in the key, it identifies that the land outside of the ring road, as a rough idea, is the general extent, and it's subject to policy YH9. And then the land within that boundary is subject to YH9C, which is the policy about defining the inner boundary. So there is a clear difference there in that plan and what those pieces of land are, and as to which policies they refer to. So the land within the ring road is clearly looking at defining that boundary. Now, there is therefore an argument that anything that when you define that boundary, anything that isn't defined as not greenbelt is new greenbelt. The plan, because it is different, we have to treat those two areas differently, and I don't think it's as simple to say, actually, it can all be treated the same. The bigger picture, though, I think, which is your second question, is then whether exceptional circumstances are required. And from my perspective, they're clearly not in this instance. We are simply about defining boundaries. And we've heard from a few people that the framework doesn't help us with this, but I think the framework does help us with this, in that if we look at paragraph 82, that confirms that the general extent is already established. So that supports the greeny yellow blob in the RSS, that's established a general extent. It then goes on to say in paragraph 83 that local planning authorities with greenbelt in their area, which we can say is York because of the general extent, should establish greenbelt boundaries in their local plan. It then goes on to say that once established, those boundaries should only be altered in exceptional circumstances. So the question is there an established greenbelt boundary in York? And the answer to that is simply no. There isn't any greenbelt boundary that's established in York. The RSS tells us that within that hatch line, we have to establish a boundary. So we're very clearly, in my mind now, at the first sentence of paragraph 83, in terms of local authorities with greenbelt in their area establishing a boundary. And only once that's been established, i.e. the plan review or the next plan, should we then looking at altering that through exceptional circumstances. So I think in terms of the process that we're going through here, we are simply setting the boundary for the first time. We don't have to show any exceptional circumstances in either the broad location or the inner area, because the framework tells us we don't have to, and it then provides us the guidance in the policies, the paragraphs after that, as to how we should define those boundaries. And actually, the comments made by Mr. Willis on PPG2 are in paragraph 85 of the framework, and I won't stray into it now because actually that's what we're going to do in some of the later questions, is look at how those boundaries have been defined and whether they have looked at the sustainable development, the safeguarding of land, not keeping land that should be permanently open. But I think from my perspective, it's not completely clear whether there's new greenbelt or not. But even if there's not, there's no need to show exceptional circumstances to start removing land, because we're not removing it, we're just defining it.
Mrs. Dukes.
Thank you, sir. I am going to go backwards in my CV just to mention that I was actually appointed at Government Office for Yorkshire and Humber with responsibilities for the Regional Spatial Strategy. At the time that the current, well, the policy YH9 was actually adopted, so I was actually party to...
Are you on the brink of giving me an insight into Government Office thinking at the time, and if so, what do you say I should make of that?
Well, this is it. My experience is still here, and the time I was in office, yes, it is.
Sorry,
still
could you just pull your microphone slightly closer to you?
Thank you, sir. So, yes, no, I think just to go back in time, I'm actually going to skip backwards to my time in Government Office, to a time when I wasn't there. The selective review of RPG 12, dated December 2004, it actually states under paragraph 4.29, the general extent of the York Green Belt was approved in 1980, and the detailed boundaries are yet to be finalised. So I think in setting whether the general extent has been defined, it has. It says quite clearly in a previous version to RSS that's less clear that, that the general extent has actually been defined, and that was in 1980. And so we now know that it's just the detailed boundaries are yet to be finalised. Policy YH9, under the outcomes, it actually says the general extent of the region's green belt has not changed, and it's referring back to that RPG to make clear that in terms of history, the RSS was still in the same position as the RPG 12, in that the general extent had already been determined. In terms of the key diagram, this is where I'm going to go and place myself back at my desk in Government Office. That's in a boundary. It's been drawn as a dotted line with the centre of York excluded from the green shading to make clear that the boundary was to be set through York's local plan. The wording of RSS itself makes clear that York was to define its own inner boundary, and that's what we're now looking to do here. We have a general extent. This plan and the York local plan, it's all about setting detailed boundaries rather than points of principle. So as such, I don't think we can actually say we're looking to define any new green belt, because we have the general extent and we're now looking at detailed boundaries. The issue that I have is around the fact that that boundary within the key diagram, the inner boundary, it's drawn extremely loosely with the idea that it would give York the chance to safeguard land, not include land within the general extent, and generally just draw the boundary where they needed to meet the development needs of York. It wasn't never intended to be drawn extremely tightly around the urban edge. Because obviously the main purpose of the York Green Belt, the inner belt, is to allow the council to meet its development needs, but whilst also looking at the historic significance and protecting the historic significance of the city. The only other thing to say is, with it being a general extent that runs around York itself, what we do need to think about is whether actually we're looking at excluding land from the green belt, in that the settlements and the new villages proposed are currently within that general extent. That denotion on the key map is solid. It doesn't have puddles to show boundaries to be drawn around individual settlements that are within that general extent. It is just there is a general extent. So I think we need to be thinking about whether this plan is actually looking to exclude land from that general extent, rather than the inner boundary, which is different, which is all about just being set for the first time.
Yeah, I think there might be a good point at which to hear the council's reply. Mr. Linus.
So there's a number of different issues being raised here. If we stick with the first one about whether there's any new green belt being created, I mean, Mr. Natkiss appeared to suggest that there was an argument that you were creating new green belt because of the dotted line. And if that proposition were advanced, if you followed paragraph 82, you would need to establish exceptional circumstances to do so, but that's not our position. We tend to agree with Ms. Jukes to the extent that the dotted line was there to indicate the extent to which boundaries had to be set. It wasn't intended to show that where boundaries were set within the dotted line, that was somehow creating new green belt. And as I've said previously...
My apologies, Mr. Linus.
Yes.
Do forgive me. I just want to make sure I understand what you just said.
Yeah.
You said that the dotted line is there to indicate the fact that an inner boundary needs to be set rather than giving any indication of where it should be set. Is that what you meant? Is that what you were saying?
Yes, and in particular, it doesn't indicate that land within that dotted line should be treated as not falling within the green belt, such that designated a green belt would involve the creation of new green belt. I think that's the fundamental point.
My apologies again. I look at the key diagram
Yes.
and I see the dark green dotted line, and then when I look at the key
Yes.
to the key diagram, and I look for the dotted line, it says York Greenbelt Policy YH9C.
Yes.
So when I see that green dotted line, is what I should have in my mind the words set out in Policy YH9C.
Yes. So the approach that we've taken to that is that the land that's been referred to that is within the white area shown on the key diagram should not be treated as land which currently does not fall within the green belt. And the plan is directing the council to set an inner boundary based broadly on the key diagram, but in particular in policy terms to safeguard the special character and nature, special character and setting of the city, and that is directing you to a boundary setting exercise. So it's not the creation of new green belt requiring exceptional circumstances, it's the setting of a boundary to protect the historic character of York. Now, there's another point raised by Ms. Jukes about what you do with the allocations, strategic allocations in the plan. I think she agrees with the approach that's been taken by the council insofar as where you allocate land that is within the general extent of the green belt, then you are looking at exceptional circumstances in those cases, ST15 being the prime example in this case.
If I can just ask, you said when the land is in the general extent,
yes,
the general extent of the green belt, then you do need to demonstrate exceptional circumstances.
Yes, if you're proposing land for release that is located within the general extent, then you do need to demonstrate exceptional circumstances, because that is land which is essentially already established as green belt that you're proposing to remove from the green belt. And ST15 is the prime example of that. We see that falling into a particular category where exceptional circumstances do need to be shown.
What about where land is not within the general extent as shown on the RSS key diagram, but might otherwise be seen as being within the green belt on the submitted policies map?
The areas that are not obviously within the general extent of the green belt, such as ST15, We recognise the point that's been raised by DIO and others, that there's an area of uncertainty about the approach to be taken in circumstances which are around the boundary. The approach that's been taken here is that the RSS doesn't say anything about the drawing of boundaries to meet any identified level of housing need. So
you'll forgive me, I hope. Is this where the point that we established earlier as being the council's view on this is that you say, should have in mind that step one in this local plan is set the green belt.
Yes.
And then step two is propose to remove land from the green belt, which involves defining new boundaries.
Yes.
And therefore, I think what you're saying is that a cautious approach should be taken, and we should accept that exceptional circumstances need to be demonstrated in those cases.
Sir, yes. I mean, the starting point here is that we say that the MPPF isn't entirely clear. We are satisfied that one is looking at a boundary definition exercise, in particular for the inner boundary, which is where this has been raised. We don't treat the dotted line as somehow meaning that we are creating new green belt within that area. We are in a boundary definition exercise, even within that whited out area, inside that dotted line. That's the starting point. Once you take that as your starting point, one then has the question of acknowledging that you're in a boundary setting exercise. How do you go through that? And the starting point for the council has been, well, there's nothing in the RSS which says you need to set your boundaries to meet any defined level of need. It suggests you should do that as a primary point to set your boundaries to protect the historic character and setting of York. And that's what the council has done. And it took the view that the definition of boundaries should take place with that objective in mind, before considering whether, as a next stage, it was necessary to move from that to release land to meet housing needs that could not be met within the boundary that they had set. Now, when one's looking then at where any new releases might need to be made, it was recognised, as I've said before, that where you're allocating strategic sites that are unquestionably in the general extent, exceptional circumstances had to be demonstrated given the underlying purposes of the Green Belt policy. We recognise that there's an area of ambiguity where you were looking at sites that are around the edge of the boundary that had been defined by the council to protect the historic character and setting of York. And this is a point raised by DIO amongst others. On one view of the framework, that is simply part of a boundary setting exercise.
Forgive me again. I'm not sure if I'm going to regret asking this question.
Right.
The areas of ambiguity, you say, do we know from evidence what the council thinks about those areas in terms of green belt function? That is to say, if you were to propose no development in this plan and simply propose a green belt, whether those areas would have been in or out?
Sir, yes, the exercise was carried out by the council initially focused on looking at defining an area for the York Green Belt without taking into account the need to address identified housing needs, because it was focused on the RSS policy, which sought the definition of Green Belt to protect the historic character of York.
Okay, so just so I'm clear, you say that, that there is in evidence the council's view about whether land would have been in the Greenbelt, although it might not be proposed to be in the Greenbelt because this plan, as I understand it at least, does include some development within it.
Yes.
I think that might be quite important. Well, it will be very important, I think, when we come to phase 2. And we look at sites in detail.
Yes, but that's the position, sir, and the boundary definition exercise was carried out in the basis I've suggested. The next stage, as I understand it, was followed by the council, was to say, well, if we are then looking to meet the housing needs that we have identified, we have gone through the boundary setting exercise so that we can understand the extent to which those needs can be met within the area we have identified. The council then satisfied itself that it could not meet those needs within that area, so it looked to other areas to meet that need. And insofar as it thought that land needed to be released to meet that need, it has applied exceptional circumstances test to that process.
So, the task for us then, do you say, is to go through that same process?
Sir, yes. We say that the appropriate approach is to follow what the council has done, which is to assess whether the boundary has been set in accordance with the direction given by the RSS, and then assess whether in meeting the housing needs that the council has identified, exceptional circumstances have been demonstrated for the releases that the council proposes. We recognise that others take a different view about whether exceptional circumstances have to be demonstrated, in particular for sites that are on the boundary, as it were, as now shown on the proposals map, because it's said that that exercise is really folded into a boundary setting exercise, as opposed to setting the boundary as the council has done and then releasing under an exceptional circumstances test. But we say the precautionary approach is to set the boundary first and then ask whether or not exceptional circumstances have been shown for the releases. And that applies not just to the land within the general extent, but also to the allocations which we've treated as releases outside the boundary that's been set as part of step 1 that you've identified.
Thank you for that. Mr. Bewley.
Thank you, sir. So we're dealing here with a situation where, I think this is clear and most people seem to agree about it, where the general extent of the Greenbelt is established, but where the plan seeks to establish or define the boundaries for the first time. In other words, we're doing the exercise which is required of councils by the first sentence of paragraph 83 of the framework. And the question you pose in question 3.1, and I'm going to take 3.1 along with 3.1a and b because they're just different sub-aspects of that overall question. The question you pose in question 3.1 is what is the correct approach, and in particular, when and how might you need exceptional circumstances, whether that be exceptional circumstances to justify creating new Greenbelt, or whether it be exceptional circumstances to justify taking you out of the Greenbelt if you're already in. And we say, certainly until Mr. Liner spoke a few moments ago, and even now I think probably the case, that there is a pretty fundamental muddle or conflation of two questions in the council's approach. And that's really important to my client's two sites. I'm not going to talk about the detail of those sites today, but they are both sites. I'm talking about ST35 NH59 QEB and ST36 Infill Barracks. They're both sites which are on the edge, right on the boundary. That's why it's important to get this right for us. So the first question you have to ask in a case like this is, where does the boundary lie? Or where should the boundary be put? It's a bit of identifying where it already is and a bit of identifying where you're going to put it if that's unclear. And the second question, once you have done that exercise, you're going to have to ask, or you may need to ask, is if you decide that a particular piece of land does fall within the green belt, then you have to ask the exceptional circumstances question about whether you can justify its release. But you don't need to ask that question if, when you look at the matter in the first stage, you conclude that the land, by reference to its relevant characteristics, by where it is on the boundary and so forth, is not in the green belt in the first place. And by the way, although it's certainly of less concern to me, there could also be a different second question, which is the other way round, which is, if you conclude that land is not in the green belt, you might need to ask whether exceptional circumstances to justify putting it in, i.e. creating new green belt. But I'm less concerned with that alternative second question. But the critical point, the really important point, is that you don't need exceptional circumstances at the first question, in answering the first question, the first stage. And equally, exceptional circumstances will not be relevant, or something like exceptional circumstances or housing need will not be relevant at that first stage.
Forgive me, Mr. Bealey.
So, yes.
You say you don't need exceptional circumstances at the first stage. Why? Is that because, in your view, it's not a new green belt?
Yes, I'm going to come back to exactly why. I just want to get the two, if I may, I'll get the two questions. I'm going to come pretty shortly. I'll come back to exactly why that is. But I just want to repeat before I do that why it matters to my client. Well, we're right on the edge of, both of my sites are right on the edge of a boundary. And we say it's wrong, completely wrong, to be asking an exceptional circumstances question about that kind of site. But, and I think I agree with Mr. Linus about this, it will be different if you've got a site which is right slap bang in the middle of the general extent, not on the edge of a settlement, there's no question of it being near the boundary at all. Well, you can't, you then do need exceptional circumstances in that kind of case, because it's obvious that you're in the green belt in the first place. And the council's muddle, what we say is their muddle, is encapsulated in paragraph 3.1.6 of their hearing statement. We will see the same thing in other places. There's a sentence towards the end of that. They say, the release of land within the general extent of the green belt does not involve an alteration of an established boundary. And that's not exactly wrong, but it's not exactly right. It's muddling the two questions, because it's failing to distinguish between the situation where you've got to work out whether you're on, which side of the line you're on, and the case where it's blindingly obvious which side of the line you're on, and you need to decide whether, notwithstanding that, you want to change the status of the land. And so you asked a question right at the outset this morning, which, if I may say so, I thought was quite helpful, a helpful way of looking at it, which is, well, are we dealing with two things? Are we dealing with green belt on the one hand and general extent of the green belt on the other? And Mr. Linus said no to that question. There's one thing, and I respectfully agree with him about that. But there is nevertheless, so in other words, if you're in the general extent, you're within the green belt. You get green belt protection, etc. But there is a critical addendum to it, which is that the difference between the green belt, once the boundaries are defined and the general extent, is that it has fuzzy edges. And so you have a question of uncertainty in some cases, but not in all, because in some cases it'll be obvious, about which side of the line you're on. Now, so you said, why do I say that's the right approach? Well, I say it's clear from the framework, actually. And a lot of people have said, well, the framework doesn't answer the question. And, I mean, on one level, that's right, because it certainly could be clearer. You could spell this out more. But actually, on analysis, I suggest it's pretty clear how you should approach it. So just a couple of points of reference. I won't read out the bits from the paragraphs. Starting point is paragraphs 79 and 80. I'll take them together. As you'll know, 79 says that the essential characteristics of the Greenbelt are openness and permanence. In other words, that's telling you something about what Greenbelt looks like. And if you've got a site, and I'm sorry, I don't want to do the site specifics today, but if you've got a site which is right on the edge of a village and it's built on, it doesn't look like Greenbelt. It's not open. It doesn't have that essential characteristic. Likewise, paragraph 80 of the 5 purposes, I won't go through them now, we all know what they are, but you're going to have to think about whether, in answering the boundary question, you're not asking an exceptional circumstances question, you're looking at the land in terms of the 5 purposes and thinking about whether it meets to what and to what extent it meets those 5 purposes. And again, if you've got land on the edge of a village which is built up, it's got nothing to do with coalescence, the village is defined separately from other settlements, then the answer is going to be it's not serving the purpose of the Greenbelt. You then move, that's the first set of references in the MPPF, you then move to paragraph 83 of the framework. So, and others who have commented on this, I say, are correct. The first sentence tells you that if you've got a general extent but no defined boundaries, then you shall establish boundaries. So that, as I say, that's the exercise that the council and now you are engaged upon. You then contrast that with the next sentence, once established, boundaries, then you don't take things out without exceptional circumstances. There's a completely clear dichotomy there. Once established, you need exceptional circumstances, but when you're defining the boundaries, there's no need for exceptional circumstances. It doesn't say otherwise. But, on the other hand, you can't use that as a basis to say any land in the general extent can be released without regard for exceptional circumstances, because you've got to do the first sentence exercise before you do the second sentence exercise. You've got to do the establishing the boundaries exercise before you get on to the release of land if appropriate. And you may need to do that for some pieces of land here. You may need to answer both questions, although my case is for my sites, you'll end with the first question. That's our primary case. Third reference in the MPPF is paragraph 85. It begins, when defining boundaries. And then it tells you you've got to have a look at various things. And it doesn't say anything about exceptional circumstances. So, what that is doing is it's picking up the first sentence of paragraph 83, and it's telling you in a little bit more detail what factors are going to be relevant to that exercise. And I won't read them all out, but they don't include exceptional circumstances. They do involve things like looking at the character of the land, getting boundaries that match up with natural boundaries and so forth. Last point is a slightly more general logical point, standing back from the detail of the MPPF for a minute. It really has to work this way, because if you think back to paragraphs 82 and 83 of the framework, you actually got 2 potentially contradictory tests. To create new Greenbelt, you need exceptional circumstances to add, and to release from the Greenbelt, you need exceptional circumstances to take away. So to answer the exceptional circumstances question, either way around, you've got to know first whether you're in or out. Otherwise, you've got a paradox. You've got to apply both at the same time. That's mad. That's crazy. So the policy has to work. It can only work on the basis you have to answer that baseline question. Is a particular bit of land in or out of the Greenbelt, before you then you work out which exceptional circumstances question you're applying, in or adding or releasing, and you decide if there is any if you need to. Now, in our case, in relation to my sites, that's not going to rise. No one says if it's not in the Greenbelt, there's exceptional circumstances to add it. our case will be that you stop at the first question, you conclude, looking at the character of the land, is not in the green belt, and that's an end of the matter. So just to conclude, and if I may sort of slightly foreshadow points I'll want to make on other, I or another may want to make on another occasion. Why does it matter? Well, it matters, I want to focus on my sites for a moment without doing any detailed analysis. As I've said, the two sites where there's a greenbelt issue, which DIO are interested in, are QEB and Infill Barracks. In relation to QEB...
I'll take these as illustrative
points. That's what I'm... I mean, that is why I want to do it.
I want to slightly...
It's illustrative, and I also... just have them slightly in mind because there will be a linkage. I'm not going to take them at any length of time. QEB is a barracks, it's covered in buildings, it's not, the land is not in any sense open. We certainly say, we'll invite you to look at it in due course. It's a brownfield site. It's on the edge of Strensall Village, which is not in the green belt. And by the way, no one said you take Strensall out because there's exceptional circumstances to release Strensall. It's just not in the green belt. In other words, it's been dealt with by the council, though without spelling this out, at the first stage. And so the only question is, where do you put the line? Do you put it on one side of my client's site or the other? And the QEB site particularly illustrates the muddle of the council's approach in my submission. Because as you know from last week, what happened with QEB is it is allocated, and there's now a proposed modification to take it out again. When it was allocated, it was not in the green belt, no doubt because the council thought that it could be justified to be not in the green belt because of the lack of, because they didn't need to address whether that, and they never explained, is that because of exceptional circumstances or that's just because it's not green belt land at all? And what they seem to have done is they took it out and they moved straight to exceptional circumstances without ever asking the prior definitional question, well, is this green belt land at all? The process meant that the muddled approach had particular consequences. So those are the points of principle that I want to make. Can I just flag up our understanding, and I think Mr. Linus may have confirmed this yesterday, but I just want to double check it because you'll see where it's important to us, is that there will be a phase 2 hearing for QEB, notwithstanding the proposed modification. So all of any more detailed points I can make on that occasion.
Yeah, absolutely. I can confirm that there will, as I said in opening today and previously, we're examining the plan as originally submitted.
Yeah. So you've got the thrust of what we'll want to say, but the approach of principle is really important to how you approach that question on the detail. So that's all I want to say. Can I just tell you, to avoid interjecting later, for question, or at any rate taking any time, my answer to question 3.5 and 3.7 will be no, essentially for the reasons I have given, i.e. the muddled approach on the one hand, and on the other, some points of detail to be addressed later on. And in the answer to question 3.9 is, this is about the modification taking our land out is not justified, again, for the same reasons, but I just may save me putting my Toblerone up later to tell you that now. I know this is strictly not. So those are the points. Thank you.
So just perhaps it would be easy just to deal with that very briefly. I mean, I think in reality this actually comes down to a debate about where the boundary in that part of Strensall should be set, and it's not necessary actually to go through a lot of the detailed submissions on the principled approach, because from our point of view, we have looked at where the appropriate boundary for the green belt in that part of Strensall should be set as a boundary setting exercise without reliance upon the exceptional circumstances test. The approach that was taken was that initially that allocation was included in reliance upon an exceptional circumstances test, but that does not mean that when we propose the deletion of the allocation that we've somehow forgotten about the boundary setting. The need to consider where the boundary should be set without applying the exceptional circumstances test. So this really falls into a classic boundary setting exercise according to the methodology that the Council has used. And I can either ask Ms Sheldon to confirm that the boundary setting criteria have been used in that part of Strensel, or, which I suggest is probably more appropriate, leaving this to phase 2.
In relation to the detail of that location, yes, that's for phase 2. Clearly, in terms of setting the methodological approach taken by the Council is something that we'll be looking at once I manage to get off the question of the principle. Mr. Tucker.
Thank you, sir. So I know you've taken everybody in turn. I don't know whether you've seen Mr. Keogh's Toblerone, but I'm happy to go first, and he's happy to defer, sir.
I haven't. I'll take you first, Mr. Tucker, and I'll then return to Mr. Keogh.
So I do want to say something in relation to the point that's just been raised by Mr. Bewley, and I'll try to avoid using the word university when I do. Before I do so, I wasn't expecting to say anything in relation to the key diagram, but so I think I need to, and hopefully it will help. So if you can turn up the key diagram, which you have within the TP1 document, on page 7. So what you can get from a regional spatial strategy key diagram to understand plan making, so it's actually been discussed by the courts in a case called Satnam against Warrington, so which if necessary we can put in the examination library. It is not intended to be on an OS base deliberately, but it does intend to include big elements so it's meaningful. So you've got the main East Coast Railway going through the centre of York. You've got the road to my hometown of the A64 from Leeds going to some unknown point on the northeast of York and heading off from the southwest towards Leeds. You don't have the inner ring road, sir. You'll notice that the roads are shown in salmon, that the rail is shown in sort of a purpley colour. You've got the branch line going down from the East Coast Main Line to Leeds, from York, etc. The courts have said you can draw some meaning from the big elements in relation to a key diagram, but otherwise, sir, it's intended to be illustrative. And, sir, the dotted green line is plainly the policy line. It's not intended to be a proxy for the ring road because the key doesn't indicate that that's part of the strategic road network which is shown on that document. It simply shows, sir, you've got an urban area with some white land between the urban area and the inner boundary of the green belt, and read the rest of the document. It tells you need to do a detailed exercise at local plan stage to define where that boundary actually is. And then you've got, beyond the dotted green line, what's said to be the general extent of green belt, also referenced back to policy YH9, which has had an awful lot of mention this morning. That's it, sir. You can't draw inferences about which side of the inner ring road, the York Ring Road that lies, sir. That's the exercise for the next stage. The other point which arises from that, sir, which is, I think, a blindingly obvious one, but I'll make it anyway. RSS was drafted at a time when we had a multi-tier development plan system. Our MPPF is written anticipating that we don't have a multi-tier development plan system. PPG2 was anticipating a multi-tier development plan system where you would have structure plan identifying where the general extent was, RSS identifying general extent, and then local plans doing the details. That's why you've got the bits in paragraph 2.6 of PPG2. But so you can meaningfully ignore what's in PPG2 because the courts have told you to. As a tool of interpretation. So you, sir, have the unhappy task of looking at a document which is a residue from a multi-tier system with single-tier guidance at national level. Happy days. So in relation to doing that exercise, sir, can I ask you to turn to MPPF 2012? Because the courts also say you're not meant to interpolate words in relation to it. That's a case called Timmings and Gedling. Which, again, we can lodge if we need to, but I don't think it's controversial. So paragraph 82, first couple of sentences deserve careful reading because it tells you general extent across the country is established and then tells what authority should be doing in terms of new green belts. It's not telling you what you should be doing about defining boundaries or taking land out of green belt. All we've got on that are the happily non-comprehensive words of paragraph 83. And paragraph 83 tells you when you apply the exceptional circumstances test. It's prefixed by a word that says once established. So, sir, you apply exceptional circumstances once greenbelt boundaries have been established. They haven't here. The hanging question, which is the point that I really want to address, is what on earth are you meant to do in relation to a site which is very obviously within the general extent of the greenbelt, and you are doing something to it by taking it out of the greenbelt? My learned friend, Mr. Linus, and I think Mr. Bewley also indicated that there's a difference of kind between what's slap bang in the middle of it, say Elvington Airfield, and something which is on the edge or the periphery of the urban area, on the far edge of the outer area of the greenbelt. There's a difference in kind, and it's difficult to disagree with that as a proposition. Difficult to disagree, not least because my client's site isn't slap bang in the middle of the general extent of the greenbelt. I avoided using the verboten word. My learned friend Mr. Linus, however, sought to draw a distinction not between those which are slap bang in the middle of the general extent, but between strategic sites and non-strategic sites. That's where we disagree. So I'm not going to make any submissions about whether you are required to apply exceptional circumstances if you have a slap bang in the middle, the ST15 example. I'm not going to make any submissions one way or the other, with one possible exception, which I'll come to in a moment. But where you are dealing with the inner edge, the true inner edge of the greenbelt, in my respectful submission, there is absolutely no warrant in paragraph 83 of MPPF to justify the application of the exceptional circumstances test. Now, it may be, and this is conceding something to the City Council, it may be that because of the very odd circumstances in York, and things don't get odder than greenbelt in York, because of the very odd circumstances in York, one might have regard to the exceptional circumstances test as one of the factors to bear in mind, but national guidance does not support, in my respectful submission, the application of exceptional circumstances for the division between sites which are strategic and non-strategic when they're on the periphery of the urban area. And that's with one exception, which also I think applies in relation to the slap bang in the middle of the green.
Forgive me, Mr. Tucker. I'm sorry to interrupt your flow.
Yes, of course, sir.
How does one set about having regard to the exceptional circumstances test without actually applying it?
Well, one has regard to it to note that in the way that I was coming to in terms of the exception, sir, which is it may very well be that you can envisage circumstances which are so gross in terms of the change to the greenbelt that they alter the general extent of the greenbelt. For example, taking out the southern half, everything south of the A64 from the greenbelt, where the general extent would be plainly different from that which is within the RSS. And it's got to be a planning judgment as to where you draw the line below that point. So everything south of the A64, definitely apply exceptional circumstances. Taking out a site slap bang in the middle of several tens of hectares in the middle of the greenbelt, probably as a matter of planning extent, you are altering the general extent and therefore apply exceptional circumstances. But where you're fixing boundaries, unless you were doing something so gross, which is where you have regard to, sir, unless you were doing something so gross like fixing the boundaries 5.5 miles from the centre of the city, then, sir, the exceptional circumstances test isn't engaged. So bringing that together, sir, where you are fixing the inner boundary of the greenbelt, unless you are altering something so obviously that comprises the general extent of the greenbelt, and we come nowhere close on my client's site, unless you're doing that, so you should not apply the exceptional circumstances test. Thank you, sir.
Shall I take Mr. Keogh first, Mr. Linus? Mr. Keogh.
Thank you, sir. I think our position is very clear and set out clearly in our representations on the plan itself and on the modifications and in our hearing statements. We have gone back and looked at previous, the history of the evolution of the Greenbelt, but as has already been said, the starting point, the main starting point is the 2009, the saved RSS policy from 2008 RSS. But nevertheless, I think the history of the evolution of the Greenbelt through the Greenbelt Local Plan and the subsequent modifications indicates that previous inspectors and plans have wrestled with this issue of setting a permanent Greenbelt whilst also accommodating development needs. And that's why we've included references to that process. In terms of where we are now with the framework, we agree that we are not defining new Greenbelt, but we strongly disagree that you have to show exceptional circumstances to, as the council puts it, release land from the Greenbelt, because what we say is you're clearly not releasing land from the Greenbelt. When you're accommodating development needs, you are deciding not to include that land in the Greenbelt. It's it's the use of words and very precise language. So we say that when account and sites are allocated for development within the general extent, they're not being released. They're simply not being included within the Greenbelt.
So for the avoidance of any doubt that I may have, do you say that that approach should apply anywhere and everywhere within what is clearly the general extent of the Greenbelt, or do you follow Mr. Tucker and others on the question of fuzzy edges, I think someone described it as?
Yeah, the fuzzy edges, I understand, because again, I've referenced, I've included the last sentence from YH9C in our submission. YH9C refers to detailed inner boundaries and defining those detailed inner boundaries. And I think one of the problems we're grappling here with is, as others have said, is that the framework and indeed the RSS didn't really explain how you go about dealing with sites that are within the general extent of the Greenbelt. But Policy H9C says that in setting the detailed inner boundaries of the Greenbelt, they should be defined in order to establish long-term development limits. The last sentence of that, subsection C, is not included within the SAVE policy, and it says the boundaries must take account of the levels of growth set out in this RSS and must also endure beyond the planned period. Now, clearly that was not included, because if it had been included, it would have been referring to levels of growth in an RSS, which had clearly otherwise not been saved. But it illustrates that there's no reference to exceptional circumstances having to be demonstrated to define the inner boundaries. And I would say the same logic has to apply when you are trying to accommodate future levels of growth within for the planned period. That again, there's no need to demonstrate exceptional circumstances to accommodate those levels of growth within the Greenbelt. But clearly the tests that are applied are the 5 tests, the 5 Greenbelt tests. It has been put to you that the way you should approach this exercise is that you first define the Greenbelt, and that will mean defining the inner boundaries. And then once you've defined the Greenbelt, if you are looking at other land that's needed for development needs within the general extent, that you have to show exceptional circumstances. But I don't think that's the case, sir, if you look at the language in the MPPF, particularly in paragraphs 84 and 85. Again, when drawing up or reviewing Greenbelt boundaries, local planning authorities should take account of the need to promote sustainable patterns of development. Now, promoting sustainable patterns of development may well mean allocating sites for development within the general extent of the Greenbelt. But also, in paragraph 85, when defining boundaries, local planning authorities should ensure consistency with the local plan strategy for meeting identified requirements for sustainable development. It's a parallel exercise. You don't define the Greenbelt and then go looking for sites to meet your development needs. When defining, paragraph 85 sets it out very clearly, when defining the boundaries, you should at the same time ensure consistency with the local plan strategy for meeting identified requirements for sustainable development. There's no mention of the need to show exceptional circumstances to meet those identified requirements for sustainable development. Thank you.
Mr. Grundy.
Thank you. And I would start off by supporting what Mr. Keogh has just said about the parallel exercise of defining your Greenbelt boundaries in line with your development needs. But unfortunately, to drag things back to the original question about is there any new Greenbelt, we say the Council is proposing to do two things. First of all, expand the general extent of Greenbelt and also then define detailed inner and outer boundaries. We agree with the points made by Mr. Natkas about the key diagram clearly not showing fingers of Greenbelt extending into the city. We talked about the strays and green wedges that the city greatly benefits from yesterday, and we say that there are other means of protecting that land from development. It need not be protected as Greenbelt, in the same way that para 86 of the MPPF talks about whether you inset villages within the Greenbelt or whether they're washed over. If they don't need to be in the Greenbelt, there's other means, such as conservation areas, as protecting that land from development. And also, in terms of the outer Greenbelt boundary, I go back to what Mr. Wright was saying about how that's expanded out from 6 miles or thereabouts. With our evidence, we refer to the proposed extension of the general extent down at Weldrake Ings. The proposed Greenbelt boundary leaps from the River Derwent to the old line of the River Derwent, which in actual fact, the furthest extent is 8.5 miles from St Sampson Square, which the Brex Lane appeal decision took as the centre of the city. 6 miles or about 6 miles does not extend to 8.5 miles, I'm afraid. So we see that as proposed extension, a clear proposed extension to the general extent.
Mr. Corsia.
A few brief points, sir. You'll not be surprised to know the Secretary of State has considered the matter of general extent many times over the past 20 years. And so the view taken by the Secretary of State has been that the general extent goes up to the perimeter of the urban area and definitely extends into beyond the outer ring, into the urban area, up to the urban area beyond the ring road, sir, or up to the ring road. So, and in all those cases, and there are again many, the Secretary of State has required the application of very special circumstances, even on sites which are allocated, have been allocated in draft local plans. So we actually, on this matter, we agree with Mr. Linus that exceptional circumstances need to be applied. And, but, sir, if you are minded not to accept the Council's submission, we think that the views of Mr. Carter about general extent do have some, where sites demonstrably fall within the general extent, the exceptional circumstances need to be shown. We think that has some force. If you were minded not to agree with Mr. Linus on that first point. And so in terms of general extent, we would say you would again look at, we would say your starting point of that should be figure 7 of the TP1 addendum, which I think is how the council have applied that. I'm not certain, but I think it might be. But sir, can I just pick up on a point that's quite important for the soundness test of justification. So Mr. Linus referred to this process which he implied has taken place in the council's undertaken of looking first at which sites are important for Greenbelt purposes, looking at development needs subsequently, and then making decisions. So, to my knowledge, that has never, if that process has been carried out, it has never been documented. I haven't found it in any documentation I have seen. And so the first documentation I'm aware of where the council has analysed Greenbelt purposes is, of course, the TP1 addendum, which was issued only after you raised questions on this matter. So the council may or may not have that in their mind, but if it isn't documented for you, we say it's difficult for the Greenbelt to be said to be justified. Thank you, sir. And if the council are going to refer me to something, do have that, couldn't they give me the reference in the library?
I'm going to ask the council to hold off from addressing that point now, because I'm going to be coming on to all of that once I get off the principles question. Yeah, is that about as much as you can take, Mr. Linus, before replying to what we've heard?
Me saying just a few words, if I may, sir. Thank you. Just taking this back to where this started, and whether or not we're looking at the creation of new green belt. I mean, for the reasons we've given, we just don't accept the argument that you should look at the key diagram and assume that land within the dotted line, which was whited out, should be treated as not being in the green belt, such that we'd be creating new green belt through the process of this plan. For the reasons we've given, which I think are supported by certainly Mr. Tucker and others, you can't read the key diagram that prescriptively. And as I mentioned in opening, and as on this occasion Mr. Cursier agrees, the Secretary of State has, in previous occasions, treated that land as falling within the general extent. And as the key diagram confirms, you're looking at a boundary setting exercise in that area, which is shown as white. Now, the next question then is, when one's carrying out that exercise, how do you go about it? And this was the point that was raised where Mr. Tucker departs from us, as well as Mr. Keogh as well, and I think to some extent Mr. Bewley. And I mean, the council recognises that there are different ways of looking at this, but in the particular circumstances of York and the RSS policy, it took the approach of saying we need to work out the area which needs to be defined as green belt in order to protect the historic character of York, because that's what the RSS is telling us to do. Secondly, insofar as one is then needing to consider housing needs, in order to assess the extent to which those needs could be met either within the urban area or within greenbelt land, one needed to go through the process identified in the RSS of identifying your boundary. Once that exercise had been carried out, one was then in a position to know where you were going to meet the housing needs that you'd identified. Now, in cases such as ST15, which are clearly within the general extent of the green belt, I don't think there's any serious debate, apart possibly from Mr. Keogh, that one is looking at applying exceptional circumstances test there. It doesn't fit exactly within the MPPF terminology for the reasons I've given, but the underlying policy objectives, we say, show that you're essentially taking land out of what is undisputably green belt, so you apply exceptional circumstances. Now, we recognise that there is scope for debate about what you do in the urban fringe areas. But, for example, and we don't actually draw a distinction between strategic and non-strategic sites in the way that Mr. Tucker was suggesting, but where, for example, if you look at ST14, clearly you would apply exceptional circumstances there from our point of view because you're within the general extent of the green belt. You have potentially other questions to ask when looking at allocations such as ST8, which are extensions, urban extensions. Now, on Mr. Keogh's view, you would just adopt that as part of your boundary setting exercise and not consider exceptional circumstances. But the approach that's been taken by the Council, which we accept as we characterise as precautionary, is to say that once we've gone through the exercise of working out what is needed by way of green belt to protect the historic character of York, if you're looking at meeting your housing needs by allocating land such as that, such as an ST8, you're better applying the exceptional circumstances test because as a matter of judgment, that's more readily to be interpreted as taking land out of the general extent. And therefore it's more precautionary to apply the exceptional circumstances test to that. Because it's more difficult to distinguish the approach taken to ST14 with ST8, even though we recognise there's scope for debate on that. And we recognise Mr. Keogh's point raised by Mr. Tucker as well, that this is essentially one sort of parallel exercise. It's purely boundary definition. But in the particular circumstances of this case and the RSS policy, we felt it was more appropriate, more precautionary to identify your boundary, looking at the particular need to focus on historic character and setting of York. And then when you are making incursions into the green belt, to apply the exceptional circumstances test to those incursions. That involves essentially a matter of judgment, we say, and we follow that on a precautionary basis. Ms. Sheldon wants to add something to that.
If I can just ask one small point. In some cases, it'll be clear, as you say, and we refer to ST15, isn't it, where things are more clear cut than in other places. Is there a map that shows both the general extent of the green belt, as shown on the RSS key diagram, and that also shows the proposed allocations, such that Mr. McCormack and I can be clear about where the fuzzy areas are? Good.
We can have a think about preparing that for you, sir.
Technically speaking, is that technically straightforward, or is it likely to cause more controversy than it's worth?
Well, I say we think about how we produce it. We need to give some thought about how that could actually be represented on a plan which combined essentially a key diagram that wasn't prepared for the same purposes as our proposal map. We need to reflect about whether that's going to assist you, sir, and how that might be presented.
Yeah, I mean, you know, if there is, frankly, any danger of a food fight about it, then I will ask that you don't prepare such a plan.
We see there's a huge danger of food fights potentially, but we'll reflect on that, sir, if we may. It may well be that it's going to cause more difficulties than help.
Sorry, I wanted to make a comment following on from what Mr. Linus said earlier, just to say that in assessing the boundaries and determining exceptional circumstances, the exercise that's been carried out has been to assess if the land on the urban edge performs greenbelt purposes. If it does, then we've asked that exceptional circumstances apply. That is the approach that we have taken. Does the land meet greenbelt purposes? If it does, exceptional circumstances should apply. Where it doesn't, and where there's land that we've identified that doesn't meet greenbelt purposes, we have included it within the urban areas.
Yeah, I think that comes back to the point that I think Mr. Linus and I agreed earlier on that the approach that the council advocates is to imagine that greenbelt boundaries had been set because the council has undertaken that assessment and then set about the business of applying national policy, which would mean exceptional circumstances. I've got that right, haven't I, Mr. Lyons? That's what you said earlier.
To those areas where we've sought to identify incursions into the green belt on the proposals map, yes. We have applied exceptional circumstances to those sites, yes, after following the boundary setting exercise that we've been debating.
Okay. Yes, I've been all the way around the table once. What I'm going to do on the second round is ask that people stick to the question that we're talking about, which is the question of principle, without deviation, repetition, or the other thing that I can't remember. Yes, thank you very much. Quite right too, hesitation. Anything that strays beyond that, I will simply say, no, stop there. That is for the following question, because I do want to make progress. Having said that, even more than progress, I want a short break. It is now 11:02, 11:03. I adjourn the hearing to resume at 11:20. Thank you.